Next matter we have scheduled for today is E23-1005-253-5555, City versus Brennan.
Morning, Your Honor. Ian Goldman on behalf of the state. Mr. Brennan?
Sir, I'm here by special appearance today.
1 second, so we can get you reported. You come in too well, so that we can pick you up.
Sir, I'm here by special appearance, and I was in a hearing on a couple weeks ago, and I invoked the duty of the court to provide jurisdiction. There hasn't even been a probable cause hearing yet to determine probable cause, and the court has no discretion to ignore challenge to jurisdiction. So I'd like to see the jurisdiction that the court has. There's been no proper pleadings filed with the court to commence any kind of criminal matter. I'm not sure that the prosecutor even has the authority to prosecute a criminal matter. That's reserved for the district or county district attorney. So this, I believe, is an administrative hearing. And I don't know how you're bringing me down here without any contract, without any service contract, employment contract. There's been no probable cause determination, nothing. I haven't been notified of this trial. I haven't been notified of the nature and cause of the accusation. I don't know how you're proceeding here.
How are you appearing today if you didn't have notice of the trial?
I got a call yesterday on my phone. That's how I mean, that's...
So you admit that you had notice?
No, sir. That's not notice.
Mr. Brennan, before you go any further, I'm just going to advise you that you do have the right to remain silent. Anything that you say can be used against you in this and any future proceeding. You have the right to be represented by an attorney of your own choice, and if you can't afford an attorney, you can make application for the public defender. If you qualify, the public defender can be appointed to represent you free of charge, together with your an application fee of up to $200. That being said, the matter is scheduled for trial today. I am going to entertain your argument on probable cause. I'm going to have the prosecutor respond to that. Do you wish to waive your right to be represented by an attorney?
I'm not waiving any rights, sir. I have nothing to waive, or even I have nothing to even argue here, because there has been no probable cause determination. There hasn't been an authorized party.
I'm going to stop you right there. Officer Copen is present in court. He's sitting at counsel table for the state. Officer Copen is a sworn officer in the township of Tom River, which judicial notice can be taken of. He signed motor vehicle summonses, complaints against you. He determined probable cause pursuant to his authority under the statutes of the state of New Jersey. So probable cause has already been determined in this matter. It is not a criminal proceeding. It is a motor vehicle violation.
Excuse me, sir. Your officer here isn't authorized to determine probable cause. This is a criminal matter. It's called a quasi-criminal matter, and the court has held that all quasi-criminal matters, criminal process has to be afforded.
All right, Mr. Ian, I'll give you a moment to respond if you wish.
Judge, I'll submit. I'm ready to call witnesses. It's over. Okay.
Sir, I'd motion for a continuance, and I also motion for your recusal. You're a judge in another matter that I'm involved in, and you showed extreme bias towards me. You've instructed your clerk to deny me record requests. There's a conflict of interest here. And I would like, yes, that's true. I have video evidence of it. Absolutely true.
If you're recording court personnel doing court business, I would love to see that, because that's another violation.
That's not a violation. That might be your policy. That's not a law or a violation. And I can go to the public. Sir, I don't want to argue with you. I really don't.
Okay.
I want you to respect me like your video said, that you're going to respect my rights.
I respect your rights.
You don't.
I've already found that there is probable cause. The officer determined the probable cause on his own. He has the authority under the state. You've offered no challenge to that with any authority by any case law, any statutory law whatsoever. So the trial is going to proceed. You can have a seat.
Sir, I cannot
stand, and we're going to proceed with the trial.
I cannot proceed in a trial where the court has not proven its jurisdiction. Does the prosecutor have any evidence of jurisdiction?
We're going to get into that in the trial. That's part
Well, no, that's a threshold matter, sir. That's the threshold matter.
And in order for him to prove his case, he's going to have to establish that there is jurisdiction. And he he's going to do that, you'll have the right to cross-examine the witnesses. If you choose not to be represented by an attorney, you are going to be required to act as if you were an attorney. You're not to be asking questions out of turn or until it's your turn to cross-examine. As I indicated, you have the right to remain silent. You do have the right to testify. You have the right to choose to continue to remain silent, which you haven't elected so far. And if you do choose to remain silent, I won't draw any adverse inference against you at all for just remaining silent. But you'll be expected to follow the rules of evidence, and you'll also be expected to follow the rules of the trial. You have taken this opportunity to file a motion challenging the probable cause in this matter. I will hear from Mr. Goldman so that we have a record of the state's position with regards to the probable cause.
Thank you. The officer is going to testify and establish probable cause as part of the testimony during the trial. So I would just ask the court that we have a hybrid where the probable cause hearing, we can start with that through the officer's testimony and then just merge that into the trial. I think that's the best way to proceed.
And Your Honor, if there was probable cause determined today, I would be afforded the right to prepare for trial. You're violating my First Amendment right to address my grievances. I mean, this is an administrative court.
Since November 9th of 2023 to challenge probable cause. You have not done so except for today.
There has been nothing filed to inform me of the nature and cause of this accusation. Nothing. There has not been a...
issued summonses, and
Sir.
you failed to appear on January 8th, 2024, March 25th, 2024, May 13th, 2024, June 17th, 2024, and looks like you might have appeared in February of 25 on this. So you've had multiple notices for you to appear. You've chosen not to. We're here today for trial, so you can choose to participate.
I have not.
You can be warned that if you leave the proceedings after they're started, that we will try to absent you.
I have not been informed, and your administrative court that has absolutely no nexus with me whatsoever, sending me a piece of paper in the mail is not how you initiate a court case. I mean, if I was an officer here or had some kind of a service contract, I have no contract with your corporate court here. Nothing. This is like McDonald's calling me down to their court.
I'm going to ask you at this point to stop. We're going to allow the state to have an opening statement. If you wish to have an opening statement, you may as well. And then we're going to proceed into the hybrid trial, which will conduct a probable cause hearing formally first. Do you wish to remain standing at the door to the well, or do you wish to come into the well?
I wish to have this dismissed or continued, and all my rights be reserved and respected, like your video said. You're disrespecting my rights. You're not following the law, and you're violating my due process rights. There's a whole kinds of constitutional violations here.
Is denied. Your request for dismissal is denied.
Well, of course, on what grounds, sir?
There's nothing pending before the court that would give it any inkling or any reason to dismiss the charge.
Really? If has been no proper papers filed by any party. There's either criminal cases or civil cases. Am I correct?
Brennan, Justice, this is a motor vehicle violation under Title 39 of the New Jersey statutes. Okay?
I understand that, and
That's not criminal and it's not civil.
is this a quasi?
I'd like to call the first witness.
Is this a quasi-criminal case, sir?
No, this is a motor vehicle violation.
It's considered quasi-criminal in the state of New Jersey.
It's under the Title 39 of the motor vehicle statutes of the state.
Once again, I move for your dismissal under the Administrative Code 114.12. You're not following the law, and you're violating my due process rights.
Your motion is denied. Call your first witness, please.
Thank you. The state's waiving opening statements. The state would like to call Officer Patrolman Adam Copeland.
Mr. Copeland, you can either testify from the counsel table or you can take the stand, whichever you're more comfortable with. Also, would you remain standing? Please raise your right hand. Do you solemnly swear or affirm that the testimony you're going to provide before the court is the truth, the whole truth, and nothing but the truth?
I do.
Can you state your name, spell your last name for the record?
It's Adam Copeland, Koepppen.
Officer Copeland, by whom are you presently employed?
The Toms River Police Department.
And And how long have you been an officer with the Toms River Police Department?
18 years.
And where are you presently assigned? Which unit?
The traffic safety unit,
And how long have you been an officer with the Traffic Safety Unit for?
10 years.
And what are the assignments and duties of a traffic safety officer?
I handle serious and fatal crashes, and investigate hit and runs, and also enforce motor vehicle violations in the township of Toms River.
And how long have you been a police officer with Toms River for?
18 years.
Which police academy did you graduate from?
Atlantic County, class number 8.
And do you have any prior law enforcement experience?
Yes, sir.
Where is that?
I worked in Wilmington, North Carolina as a full-time sworn officer
From when to when?
from 2004 to 2007.
And what kind of work, where were you assigned when you were with Wilmington, North Carolina?
Patrol.
I want to direct your attention to November 9th of 2023. Were you working on that day?
Yes, sir.
And you were assigned to traffic safety?
Yes.
And what was your shift on that day?
Day shift from 6 a.m. to 5 p.m.
Were you working alone or with a partner?
I work alone.
And were you in a marked unit or unmarked unit?
Marked unit.
That morning at approximately 7:28, did you come into a contact with a Donald Brennan Jr.?
Yes, sir.
Is he in court today?
Yes, sir.
Can you identify him?
Yes, sir. The gentleman right here standing behind me.
Let the record reflect that the defendant has been identified in court by officers.
Tell us how it came to be that you had an interaction that morning with Mr. Brennan Jr.
While on patrol, I was driving northbound on Blue Avenue near College Drive, Ocean County College. I observed a blue pickup truck with a blue placard where the license plate goes with some numbers, and the plate read something to the effect of Federal Motor Vehicle Carrier, US DOT. And
Have you ever seen that type of license plate before?
in my 21 years in law enforcement, I've never seen any license plate that looked like that before.
What did you do upon making these observations?
I just confirmed what I saw, and I knew I had probable cause to stop the vehicle for possible violation of fictitious license plate.
And did you stop the motor vehicle?
I did. I activated my lights and siren, and the vehicle pulled into the Wawa, Hooper Avenue near South Shore Drive.
Okay, ultimately, was Mr. Brennan charged with motor vehicle offenses?
Yes, sir.
And was one of those motor vehicle offenses for having a fictitious plate?
Yes, sir.
Okay, with regards to the probable cause hearing, Your Honor, I would submit.
All right, thank you. Mr. Brennan, I'll ask you if you have any questions of this officer at this time with regards to his testimony.
The probable cause,
Sir, hang on. We're not taking arguments.
I'm not taking arguments. I was charged with a fictitious plate, and the plate that I had meets none of the elements of a fictitious plate.
Do you have any questions of this officer based upon his testimony?
Nope, I have no questions at all. I'm going to exercise my Fifth Amendment right because I object to this whole hearing because probable cause hasn't been determined by a magistrate, nor has there been any primary pleadings filed into this court that would commence a criminal matter or civil, quasi-criminal, or anything like that.
Those arguments, those objections are overruled. The court finds
I'm just renewing my objections.
Officer Copen to be credible in this matter. He testified that he observed a plate that he had not recognized, believed it to be fictitious. He effectuated a stop on the motor vehicle, which was operated by Mr. Brennan, which the officer has testified identified in court as being the operator of the vehicle. The court finds that there was a reasonable and articulable suspicion that there was a violation of the New Jersey motor vehicle statutes at the time of the stop, and based upon the totality of circumstances, the state had established probable cause for the issuance of for the stop at this point. Thank you.
After effectuating your motor vehicle stop, did Mr. Brennan pull over?
Yes, sir.
And where did he pull over?
The Wawa, Hooper, and South Shore.
Okay. Did you approach Mr. Brennan?
Yes.
From which side, driver or passenger?
Driver's side.
All right. Did you have any interactions with Mr. Brennan?
Yes.
Why don't you take us through that interaction that you had with him?
I walked up to the driver's side. I identified myself, Officer Copeland, Toms River Police Department. I requested his driver's license, registration, and insurance card. Immediately, he became argumentative with me and tried to establish legal grounds of why he was not required to provide any of those documents to me.
Okay, so what did you do next?
I just continued to talk to him, tried to use my de-escalation tactics I've learned through 21 years, and just trying to explain to him I just needed his license. I can verify who he was, issue him his motor vehicle summons for the fictitious tag, and he just continued to legally debate. Eventually, I realized I could see the VIN of his vehicle and from the outside, and I was going to just look at it and write it down, at least identify the vehicle that I had stopped. When I attempted to do so, he had paperwork that was on the passenger seat of his car that he quickly grabbed when he saw what I was doing, and he used it to then cover the VIN number in his dashboard, so I could no longer identify the vehicle.
What did you do next?
I requested backup. I requested supervisor as well, and went back to my vehicle while I waited for them and tried my best, to research various tools in our Spillman database to try to identify the vehicle and the subject that I was dealing with.
Were you able, did backup arrive?
Yes.
And who arrived?
The supervisor, Sergeant Ruiz, I don't recall who the other officer was.
Okay, by the time Sergeant Ruiz arrived, were you able to obtain Mr. Brennan's identification at that point in time?
Prior to?
Yeah, prior to.
No.
And Sergeant Ruiz arrives, and what did you and Sergeant Ruiz then do?
I explained to him what I had stopped him for. He then stated he would try to speak with Mr. Brennan because sometimes people connect differently with other officers. And then essentially he ended up having to explain to Mr. Brennan that he was legally required to identify himself, whether it's by providing his name or his driver's license, and if he did not do so, that he would be arrested.
Did Mr. Brennan Jr. ultimately provide his credentials?
He just provided his name and his date of birth.
Okay, and what did you do with that information?
I then returned to my patrol car while the other two officers stayed with him. I looked him up in our Spillman database, and then further, once I found his driver's license, I looked him up in the New Jersey motor vehicles database, and was able to positively identify him from the driver's license picture that was attached. I was able to see that his license was currently at that time suspended in the state of New Jersey.
Out of where? Do you recall?
I do not recall.
And based upon learning this information, where did your investigation take you next?
A warrant, I believe out of Monmouth County, had I won't say pinged on my computer. When you run his driver's license, some warrants will make a noise and notify you and pop up red that this warrant exists. So then I had to contact our dispatch to have them go into the system to confirm that that warrant was a valid warrant. Once that warrant was confirmed by the issuing agency, I then approached the vehicle to advise Mr. Brennan that he was under arrest.
Okay. Now I just want to take you back a second. When you did your New Jersey motor vehicle lookup with regards to Mr. Brennan, what, if anything, did you learn from entering his information into the system regarding his driving?
They were suspended in New Jersey.
When you approached Mr. Brennan after doing research on him, you had just testified that you took him into custody. Was that correct?
Correct.
And what was the basis for taking Mr. Brennan into custody?
Valid warrant.
Okay. And ultimately, you issued Mr. Brennan some motor vehicle summonses, did you not?
Yes.
Do you recall how many summonses you issued him?
I believe 4, sir.
And what were those summonses?
Unregistered vehicle, suspended driver's license, fictitious license plate, and failed to exhibit insurance card.
With regards to issuing him the driving with suspended privileges in violation of 39:3-40, why did you issue Mr. Brennan that summons?
Because he was operating a motor vehicle in the state of New Jersey, specifically in Town River, while he currently had a suspended driving privilege.
Okay, and you also issued him a summons for not having proper valid registration in violation of 39:3-4, is that correct?
Yes.
And what was the basis for issuing him that summons?
Once he was under arrest, I moved the papers and I was able to see the VIN. I also obtained expired insurance and registration from the glove box. And I ran the VIN, and the VIN showed that the vehicle was last registered in the state of New Jersey in 2022.
Okay, and who is the vehicle registered to that he was operating?
Donald Brennan,
Donald Brennan or Donald Brennan Jr.?
Jr., sorry.
And you also issued him a summons for 39:3-29C, failing to exhibit a valid insurance card. What was the basis for that?
At no point during our interaction had he ever provided any valid insurance card.
And did you ask him for his insurance card?
Yes, sir.
And lastly, you issued him a summons for violation of 39:3-33A, is that correct?
Yes.
Now, ultimately, why did you do that?
Because it was determined that the placard that we had in place of where license plates go is not a valid placard issued by any of the United States of America, which the states are responsible for registering motor vehicles, and it appeared to be some type of either homemade or ordered off the internet fictitious license plate, and did not identify the vehicle or where it was registered to.
Judge, I have in my possession what I'd like to have marked as Exhibit S1.
I object to that. That's hearsay.
Hold on 1 second. He hasn't identified it yet.
Judge, I have in my possession a document. It's a certified, it's titled MVC Certified Driver Abstract. It has driver's license B734-1173-000-1654.
Objection.
Donald Brennan Jr., 52 Bowline Street, Beechwood, New Jersey, 08722. I would like to have this entered into and marked and entered into evidence as states Exhibit 1 as a business record.
I object to that. That's hearsay. There's no party here that's going to come testify to that.
Your objection is overruled. This is an exception to the hearsay
Oh.
rule by
Oh, okay.
certified abstract and a business record. I have the abstract, which consists of you presented.
Am I going to be able to cross-examine the person that wrote that?
Hold on 1 second. Mr. Prosecutor, this is there's 9 out of 10 pages presented, unless nope, there's 10 of them. Okay. So states Exhibit 1 is marked for identification purposes.
Now,
Hold on.
oh, sorry.
And I'll ask that we provide a copy of this to Mr. Brennan to review. That is the original. Do you have any additional copies?
Sorry.
Okay. Why don't we take a brief recess? We'll mark that so Mr. Brennan can have that in his possession as an exhibit. Yes. Where should we want it? All right, we're back on the record. The court has marked Exhibit S1, which is the removed MVC Certified Driver Abstract presented by the city. Marked for identification purposes, a copy has been provided to Mr. Brennan. Mr. Brennan had objected to the marking of this. It has not yet been offered into evidence. And Mr. Brennan cited the hearsay basis for his objection, and the court has overruled that objection because of the business record exception to the hearsay. Mr. Goldman.
Then I have a few more questions. Number one is, what did you do with that quote-unquote fictitious plate?
It was removed from the vehicle and then placed into evidence here at the police department.
In looking at Mr. Brennan Jr. today, does he appear, does he look the same as he did on that date?
Yes, sir.
And are there any distinguishing characteristics that you could make regarding that you would recognize as to when you stopped him compared to today?
His beard is cut pretty much exactly the same way, his gray hair, his build.
And to the best of your knowledge, do you know if Mr. Brennan Jr. has any convictions for, maybe overstepping here, are you aware if he has any prior convictions for driving with a suspended driver's license?
I believe he has at least 2 prior.
I have no further questions, Your Honor.
All right. Mr. Brennan, at this time, you have the ability to cross-examine the witness on his testimony. This is not for you to testify or call any of your own witnesses. This is just simply for you to cross-examine the witness on his testimony. Do you have any questions of the witness?
I have no questions of this witness, no.
Okay, thank you. You can step down, Officer Copeland. And Mr. Goldman, do you have any?
The state has no other witnesses at this time. The state would like to move S1 into evidence before it concludes.
S1 into evidence without objection. All right, the state rests.
The state rests at this time.
All right, Mr. Brennan, the state has rested its case. At this point in time, you have the ability to call your own witnesses today, take the stand yourself and testify, being subject to cross-examination, or you may choose to invoke your rights and remain silent.
I was not informed of this matter, so I have no witnesses to call. I'm going to invoke my rights. I invoked my rights at the scene, and this officer told me I didn't have 4th and 5th Amendment rights. And a Terry stop, that's akin to a 5th Amendment violation. I have the right to remain silent there, but I wasn't given any rights at the scene, just like today in this court here, where you're violating my rights. I objected to your hearsay document. Is there a signature on this hearsay document from any party that I could hold accountable that can come in here and testify to it, that you denied it? I mean, it's obviously a hearsay. It's not an exception to the hearsay rule. I have no questions for your officer. I have no witnesses to call because I was blindsided by this, by the court. You haven't provided fair process whatsoever, or any service of process whatsoever. You're just violating my rights in a continued fraud. This is what this is. It's fraud, and it'll be proven in court.
Mr. Brennan.
Yeah, so the officer testified that the truck had a registration that wasn't registered. The truck was registered. It was registered at that time. That was a lie. The officer testified that I gave him my name. The only thing I gave him was Don Brennan, or Don. I didn't give him my last name. The officer went into my truck and searched my truck without a warrant. That's how he got my name. Searched through my truck, got my wallet, and then got my license. The other officer took my property off my truck without due process of law. I don't see where the government and any agency in the country can take somebody's property without due process of law. That's another violation of my rights. That's all that's happened here, is my rights have been violated. I haven't lost no driving privileges because I don't drive. I exercise my right to move my property along the highways that which is replete in American jurisprudence. I had no plate from New Jersey, so the officer would have had absolutely no reasonable articulated suspicion of me committing any type of New Jersey motor vehicle violation. Furthermore, under New Jersey Motor Vehicle 3931, the very first thing in Chapter 3 says automobile, fire engines, and such self-propelled vehicles neither engage in the transportation of hire of person or the hauling of freight is accepted from the chapter, which would mean my motor vehicle that is not hauling freight or hauling any people for hire would be accepted from the chapter, which goes right along with the Federal Transportation Code, and the New Jersey Motor Vehicle Code is written under the directive of the Federal Transportation Code. The government has the authority to regulate commerce under Article 1, Section 8, Clause 3. They don't get to deprive people of regress and egress of the public highways that they pay for so that they can sustain their life, pay their bills, feed their family. They didn't take my license for drunken driving or reckless drive. I've never been charged with any of that. I've never been charged with a crime ever. My license was suspended for my truck when I was out of town. From sitting in my house, the registration had expired, and the registration was already paid for, but motor vehicle hadn't renewed it yet. 2 days after the expiration, it was suspended. Then I wasn't allowed to enter a public accommodation. So I'm not here because I'm this crazy drunk driver or reckless driver. I have over 40-something years of driving my vehicle. I used to drive my uncle's truck all over his farm when I was 10 years old. I have absolutely no detriment to society whatsoever. But a drunk driver, well, he can still go to work and just blow into a little thing and drive all over the country. But me, a guy that has, 40-something years of experience driving on the roads, now, somehow I'm causing a detriment to society because I lost my license because of an unregistered vehicle parked in front of my house that's parked there every day for 15 years, which the municipal code says it can't be parked on a highway. I don't live on a highway. I live on a street. And then if you read through Title 40 of the municipal codes, streets, highways, and roads have separate designations throughout. So my license was suspended without even lawful authority to suspend it. And now I've been dragged down through all these courts, and there is going to be retribution. I've been dragged through here by my public servants and caused massive amounts of damage. And if you think that you can keep me from feeding my children, feeding my wife, paying my mortgage, and every other thing, you're very wrong. You've taken my property without due process of law, and all you have done is run a sham fraud hearing in an administrative court that has nothing to do with me. And I mean nothing. You have no evidence of a contract. You have no evidence of a nexus that ties me to this court. You have violated my rights. We have young men and women that we send overseas to die for the republic and for the rights of the people. That's a joke. We find out that our administrative agencies, through the Department of Government Efficiency, they're all corrupt. They're all stealing from the people. And it's no different right down here in our little town. And for you people to disrespect the rights of the citizens, it's abhorrent. I don't work for you. You work for me. I own the streets. I'm part of the public. I have the right to use those streets. I'm not driving on the street like a crazy man, and if I was, well then, by all means, pull me over and give me a ticket. I can't be charged with a motor vehicle crime when this officer doesn't even have a license plate that would give him reasonable articulated suspicion to say, yep, he's operating in commerce according to the regulations of Title 39.3, number 1 under the New Jersey Motor Vehicle Code or the Federal Transportation Code. None of that. But yet you'll find me, you'll steal my money without due process, you'll take my stuff, that's theft and conversion. I'm going to reconcile it all, I promise you. This is ridiculous that yous are doing this to me. It's ridiculous. And I'm not going to let it stand. I have spent 5 years of my life, thousands upon thousands of hours, reading the law. I'm not a sovereign citizen like this man defamed me as. I'm someone who's actually taken the time to understand the laws of our country and how our government operates on paper. That's what I've done. Because, in case you haven't realized, things are pretty bad here in America, because we have every government agency that are just violating people's rights, usurping the Constitution, and doing horrible things to the people.
At what point am I supposed to object for this?
You can object anytime you like.
Overbroad and have nothing to do with the...
It has everything to do with it.
Argument, is this in your defense? I'm so confused because we're just going in circles, and at this point, I think enough latitude has been given, and I'm just going to object because it has no relevance to the findings of this case.
I object to that. It all has relevance.
I'm going to overrule the objection of the state. The defendant has chosen to waive his Fifth Amendment privilege and testify here before the court. So I'm going to allow it. Anything further?
Nope.
Very well. Anything further from the state?
I'd like to give a very quick closing argument.
Yes.
Because we live in a country that has rules and that has standards, and these safeguards, these constitutional protections are put in place for everybody. And when they're broken, right, you must find guilty. And in this case, there was a motor vehicle stop that was effectuated back on November 9th, 2023. In the morning, Officer Copen stopped the vehicle for having the fictitious plates.
Objection.
Sir, you can't object during this closing.
He stopped the vehicle. The defendant was uncooperative. The officer had to call backup. Backup spoke with the defendant. He gave information. The officer was able to identify that Donald Brennan Jr. was operating the motor vehicle. There's nothing to disqualify the identification aspect. In fact, the defendant never even denied that he wasn't driving. That's not the issue. As to operability or identification, during the course of the investigation that took place at the Wawa, Officer Copen was able to verify and confirm that the registration was not current, as he testified to, and there's been no, it's a credibility finding, but there's been nothing to the contrary other than the defendant calling the officer a liar. The officer asked Mr. Brennan for his insurance card, which he could not provide, hence the 329C. He was able to confirm through a warrant that the defendant's driving privileges were suspended. That was confirmed through S1, hence the 340. And then with regards to the 333, candidly, Your Honor, the 333 may have been, I think he was charged under a 333A. It's too late. It's past the statute of limitations to amend that to a 333. But there was a fictitious place which was taken into custody and brought into evidence. And so for those reasons, the state is asking that the court find the defendant guilty for those summonses. And with that, we will submit.
First, addressing Mr. Brennan's argument with regards to due process. There has been recognized case law established in State v. Ferrier at 294 New Jersey Super 198, 682 Atlantic 2nd, 1227, an active case from 1996, that an attack on the lack of due process surrounding any administrative license suspension may not be attacked collaterally in court, but rather must be challenged either at the Motor Vehicle Commission or on appeal from the final determination of the director of the appellate division. Either of which have been effectively by Mr. Brennan. As such, the due process argument does not carry any weight. The United States Constitution recognizes that the right to travel, but traveling does not equate to driving. The Constitution, travel refers to moving freely between states, but not the unlicensed operation of a vehicle, and this was reinforced in Sands versus Roe, 1999 case at 526 U.S. 489. New Jersey Motor Vehicle Statutes 39329 requires that a motorist who operates a motor vehicle in New Jersey must carry a New Jersey license and registration card as well as an insurance card. in the state of New Jersey and in other states that have been held, driving is not a right, it is a privilege that comes with rules and regulations, including driver's license and vehicle registration. That's pursuant to Henry versus Maryland, at 235 U.S. 610, 1915, which conferred the states the rights to regulate the use of motor vehicles on their roadways, emphasizing that driving is a privilege subject to reasonable regulation under the state's police powers. The claim that traffic laws only apply to commercial use was addressed in City of Pendleton versus Standerfer 2015 case. Citation is 297 OR 7.5, 688 P. 2nd, 68, 1984. And the defendant's presence in this state is consent to the laws of that sovereignty. That being said, the court finds that the state has established probable cause for the stop based upon the credible testimony of the officer. That has already been the law of the case, and we established that early on in that probable cause hearing. The state has proven beyond reasonable doubt that the defendant operated a motor vehicle. The defendant was identified in court, that the operation was during a time of suspension. That time of suspension can be proved by direct evidence or circumstantial evidence or admission by the defendant. The defendant chose to waive his Fifth Amendment rights while speaking to the court and admitted that his license was suspended, admitted the details of that it was suspended for parking an unregistered vehicle. Again, he had not administratively challenged that as he was entitled to under his due process rights with the Motor Vehicle Commission. S1 indicates that there are two private violations for 3940 driving while suspended, one occurring September 16th of 2021, this in HQ 35, and another prior to that in April 24, 2016, there was a violation for operating while suspended. The defendant has testified that he has previously driven for approximately 40 years. So in order to obtain a driver's license, he needed to complete the motor vehicle testing, not only the written exam as well as the operational exam. And by passing the written exam, the defendant is conferred the understanding of the motor vehicle laws of the state of New Jersey and the requirements to have a license, and in fact he availed himself of that privilege by obtaining a license some 4 years ago. So the state has proven all the elements in the 39340 charge. The state, through its testimony, again the credible testimony of the officer, has proven that the defendant did not have a valid insurance card, which is required under Title 39329C, and his vehicle did not present same to the officers. So the state finds, the court finds the defendant guilty of the 39329C beyond a reasonable doubt as well. The court also finds that the state has proven beyond a reasonable doubt by the credible testimony of the officer that the defendant was unable to produce a valid registration card, and in fact confirmed through the motor vehicle records check through the VIN number of the vehicle that the vehicle was unregistered at the time. The court finds no testimony or evidence to the contrary of anything that was presented, no credible testimony or evidence to the contrary of anything that the state has presented in this matter, and the court finds the violation of 39304 also has been proven beyond a reasonable doubt. With regards to 39333A, the court finds that that matter is a charging statute and was improperly charged and not sufficiently amended prior to the expiration of the statute of limitations. The court will enter a direct verdict of not guilty on that particular charge.
Judge, I think the 90 days at this point, sentencing for a third 340 is 10 to 90 days, based upon the complete willful contempt and hate that he has. I think that there is a need to deter this type of conduct moving forward, so that the defendant does abide by the rules of the state of New Jersey. And I saw no remorse here whatsoever that the court should warrant a 10-day suspension or anything less than 90. His driving record time. He has 2 prior 340s since 2020. I'm asking for the max penalty. I think it's appropriate for those reasons. 10-page abstract.
I was going to ask you what specific section under 340 you're referring to that would allow him to take a sentence.
I thought it was under A, isn't it? Could be wrong.
I believe it's just a 10 days.
Just a 10. All right. I'll submit to the court anyways. I thought it was a 10 to 90. Could be wrong.
All right. Mr. Brennan, did you want to present any mitigating factors to the court?
Sir, there's no evidence of any mens rea that I've willingly broken any laws. I believe under Title 39(3), number 1, which hasn't even been addressed by this court.
I've already found you guilty of the charges. Do you have any mitigating factors with regards to sentencing that you'd like to present to the court?
Yes, I believe that this sentence should be waived. There shouldn't be no jail time for this. I'm not, he has an abstract, they're not for any driving offenses they're so minuscule, and they're literally for basically revenue generating statutes. That's what they're for. I'm not a criminal. I don't belong in jail, and it's just ridiculous to even consider that. There's no mens rea. In a criminal matter, there must be some mens rea. Actus reus. There's none of that. They've proven none of that.
Thank you, sir. The court has already ruled that this is not a criminal matter. Therefore, the arguments of the defendant are not applicable in this matter. The court finds that there was prior violations, as indicated on the record, on September 16, 2021, with a violation of 340, with the conviction, and also on April 24, 2016, a violation of the 340 statute. The defendant, under the statute, is assessed a fine of $1,007, $33 in court costs, a 6-month consecutive license suspension to any that he has, 10 days in jail. Can we check the jail records to see how much credit he has?
Yeah, it's going to take a little bit of 2 years.
And we're going to check on the jail credit for that. With regards to the 3934 charge on summons E23-10053, the court will accept the guilty plea. It's a $107 fine, $33 in court costs. With regards to the 329C charge on E23-10055, impose a $157 fine pursuant to the statute, $33 in court costs. The court has already entered a directed verdict of not guilty on E23-10054. Mr. Brennan, while we're checking on the jail credit, you have the opportunity to request the court to stay your entire sentence pending any appeal.
Yes, sir.
An appeal of this matter must be filed within 20 days.
Yep.
It must be filed with the Superior Court of New Jersey.
Yes, I'm aware.
Are you asking for the stay?
Yes, sir.
All right. The court will impose the stay, but I'm just going to ask for all the record take a brief recess so we can give you the appropriate jail credit as part of your sentence. Please stand up. Okay.
Your document?
What?
We're going to do you can go in now. Let's go back on.
Excuse me, can I have the prosecutor's name?
I can't address you directly now. Mr. Prosecutor, defendant is asking for your...
Ian, that's I-A-N, Goldman, G-O-L-D-M-A-N.
Thank you.
All right, Mr. Brennan, I've had the opportunity to review the jail records. It appears that you did serve 1 day in jail after this summons was issued to you. That was on December 31st, 2024. I'm going to give you credit for that 1 day. So the balance of your sentence is 9 days. I'm going to stay the entirety of your sentence for 20 days. If you do not perfect your appeal within a 20-day period, the sentence will be, the stay will be lifted, and you will be subject to an arrest warrant to complete the sentence. Understood?
I sure do.
All right. Please maintain a transcript of this, and you can also receive a copy of the disposition. That will conclude the matter. We'll offer.
Dismissed?